Good morning, everyone. Warm welcome to our Clark's Legal webinar this morning, Planning the New Normal, Programming and Dispute Avoidance in a COVID-19 World. My name is Stephen James. I'm a partner in the construction team at Clark's Legal. I'm joined today by my colleague, Ruth Wilkinson. I'm delighted to also be joined by Tom Francis, who's a delay expert at Decipher. We have the facility to ask questions if you like during the webinar, so pop something in the chat and we'll come to that at the end. By my count, I think we're just in the 11th week since lockdown, and we thought it'd be interesting just to really take stock. Now we're getting back to what might be as normal as things are for the foreseeable future, and see what challenges there are in the industry on site and practical ways about how we may deal with those. So I have three presentations. Ruth is starting off by looking at the site operating procedures and the industry recovery plan published a couple of days ago. Tom will follow with a session on programming issues arising from COVID, and I'll wrap up by looking at the current landscape for dispute avoidance and dispute resolution. So with that, I'll pass over to Ruth.
Thank you very much, Stephen. So yes, I am Ruth, and I hope you're all safe and well at home, no doubt. Thank you very much for joining us today. And my intention is to give you a brief overview of the site operating procedure and the industry recovery plan that was published on the 1st of June by the Construction Leadership Council. So before I got started, I thought it would be helpful just to have a bit of a recap of the types of current issues that are being dealt with on site by contractors and subcontractors, and of course employers as well. Many of the items that are listed on this particular slide will lead to delay and disruption and possible claims down the line. I think it's important, and part of the reason we've organised this webinar is to try and understand how best to try and deal with some of these issues and to deal with the new normal that we find ourselves in. Tom, of course, is going to look in a bit more detail at the programme, and Stephen's going to look at the dispute resolution procedures, in particularly and including the Construction Leadership Council guidance on contractual best practice and the associated government guidance. For my part, I'm going to focus with the issue of compliance with Government, Public Health England and industry guidance and restrictions, which is intended to protect the workforce and minimise the spread of infection, the spread of COVID-19. So moving on, and before we start to look at the site operating procedures in any particular detail, just to put it all into context, in England, construction sites were not required to close when lockdown was announced on the 23rd of March. And the message from government was that works were to continue, but to follow Public Health England guidelines on social distancing. On the 17th of March, so before the lockdown, the Construction Leadership Council wrote to the Prime Minister requesting that construction sites remained open and the construction industry remained operating. Now, as we all know, there was a lot of confusion in those early weeks, and some employers and some contractors took a decision to close many sites. Some continued to operate the sites, and those that did continue to operate the sites sometimes took a brief hiatus in order to work out how they would manage to operate safely and within the confines of this particular new guidance. Now, the Construction Leadership Council set up in the very early days a COVID task force where members of various industry and trade bodies led by the Construction Leadership Council were meeting on a daily basis with government to talk about the particular issues that were important to the construction industry, and there were various outputs as a result of this. So various letters and missives about fair payment, etc., etc. But one of the key things that came out of it was in relation to the site operating procedures. So these guidelines on how to operate on site. So I appreciate these sites are quite detailed. I don't want to go through the minutiae of the particular site operating procedures. You're probably better placed as technical people to deal with this than I am, but I just wanted to kind of give you a bit of an overview of the particular ones. So the first site operating procedure was actually released on the day of lockdown on the 23rd of March, and it made it very, very clear that work should only continue if it can be carried out under the guidance issued by Public Health England. It can be undertaken without compromising on health and safety in accordance with the site operating procedures, and that workers, importantly, will be able to travel safely and responsibly to sites. And this was a particular problem in areas such as London, where everybody was relying on the public transport network. So the operating procedures gave practical guidance and suggestions on how to deal with the particular issues presented by social distancing. There was a second version of the site operating procedure that was issued and withdrawn on the same day, on the 2nd of April. It caused some confusion. There was a lot of negative feedback, so it was removed. Then we ended up with version 3, which was issued on the 14th of April 2020. And that introduced some changes to the previous version, to version 1. Of course, version 2 never took effect. I think probably the key point about the version 3 of the site operating procedures was the recognition that 2 meters wasn't always achievable. And so it started to suggest certain mitigating action that could take place. I suppose the challenge for employers and contractors in relation to the site operating procedure is the need to assess for themselves whether the works are safe, and carrying out those risk assessments is absolutely critical. On the 11th of May 2020, the government issued its own guidance on working safely during the coronavirus, and this was made up of 8 parts relating to different types of workspaces. And one of these, called construction and other outdoor work, specifically related to construction. Why they think all construction takes place outside, I'm not quite sure. Now, this guidance applies to England only, although there was input from the devolved authorities, but the specific guidance for Northern Ireland, Scotland and Wales. And of course, as you're aware, Scotland actually took the decision to close many of their construction sites. So, like I said, I've summarised very briefly some of the key points that came out of this guidance. On the 18th of May, the Construction Leadership Council issued version 4 of the site operating procedure, which was updated to incorporate the various changes in the government guidance that have been released on the 11th of May. And I think it's fair to say that the changes here were fairly minimal. The most significant one was the removal of the requirement for face-to-face contact to be minimised to less than 15 minutes. And there were also links in the new guidance to personal protective equipment sections of the government guidance itself. So this is the version 4 is the latest version that we are currently, and sites should be currently working with and operating on. So as I started to think about kind of the impact of the site operating procedures on sites, on the stakeholders, on the clients, on the contractors and the subcontractors. And I suppose the first and most important question, well, is it actually binding? Now, of course, it's guidance, so it's not got the force of law. Obviously, the parties, companies, people, etc., must comply with government guidance on social distancing in relation to COVID-19. There's particular guidance that's been issued, which we've outlined in relation to construction. The site operating procedure is guidance, but there's been repeated calls by government for industry to follow this, including an open letter to industry, which was written by Alex Sharma, the Secretary of State for Bays, who encouraged members of the construction industry to comply with the site operating procedure. It's important to note that it doesn't supersede any legal obligations. So, for example, all the ordinary health and safety law and regulations. And I think it's also fair to say that there's been very little guidance on how it interacts with those laws and regulations. For example, there's no guidance that I've been able to find in terms of how it's meant to interact with the CDM regulations. So what are the consequences of failure to comply with the guidance? So it's clear from the later versions of the site operating procedure that this possible enforcement action can be taken by the Health and Safety Executive. They actually put a hold on their site inspections for some time, and these recommenced on the 20th of May. There's also a possible breach of contract, depending on the terms of your contract, of any contractual obligations that you may have to comply with health and safety law, etc., etc., and also to provide a safe working space for your employees and your subcontractors. I flagged up on the slide that there's a possible failure to mitigate if you don't comply with the site operating procedure. For example, and this is what makes it quite tricky, because if you say, for example, well, we can't comply with the site operating procedure, so we're going to suspend our works, that could cause you all sorts of problems about whether you're entitled to suspend your works and what the consequences of that is under the contract. And it might be actually that you would have been able to show that you could have complied with those requirements, or another party could have showed that you could comply with those requirements. So it's all going to very much depend on the particular facts that you find yourself in and the contract itself. The last bullet point is, are you entitled to stop work? And I think it's really difficult to say either way, and it's quite clear that the message that's been given so far has been an overriding one of trying to collaborate and have open and transparent discussions, and that's the message that was given to the public sector right at the beginning, and that same message is being made to the private sector through the recent best practice to contractual responsible behaviour guidance published by both the government and the Construction Leadership Council that Stephen's going to cover in a bit more detail. But the intention is that, you know, the contracts were not set up to try and deal with the circumstances that we now find ourselves in, the practical circumstances and the consequences of those. So there's very much an encouragement on the parties to try and collaborate and discuss what the particular issues that they're experiencing, and to try and find a way to resolve this. So what's the effect on the contractual obligations themselves? So who's going to bear the burden in terms of cost and time if works become more complex, lengthy, or more expensive as a result of compliance with the site operating procedure? Well, a typical lawyer's answer is hard to say, completely hard to say. It very much depends on the particular circumstances, the factual circumstances on site, also on the terms of the contract itself. But I think as a point of general principle, it's very difficult to see how a contractor can be relieved from the burden of having to comply with these types of obligations. Of course, on any particular site, it may be that the burden of compliance is shared between different parties, and again, that very much depends on the setup of the site and who has responsibility and ownership of that site. It's interesting to note that in the industry recovery plan that I'm going to touch on a little bit shortly, it specifically identifies in the second phase of that plan, so there's 3 phases, the second reset phase, that there needs to be new approaches allowed to compensate for the loss of productivity. So there's this express recognition that complying with the site operating procedures with social distancing is going to have a very clear and damaging effect to productivity on site, and hopefully Tom will cast a little bit more light on this. A few more in terms of potential issues on contractual obligations is sometimes you find change in law provisions. So if there's a change in law, it might be that you're able to get the benefit of that and claim for additional time and money. There's a real question mark about whether or not the site operating procedure would entitle you to do that, given that it's guidance rather than being actual hard law. Force majeure, we've heard a lot of chat about force majeure and parties relying on force majeure provisions to excuse delay and non-performance as a result of COVID-19. And I suppose an interesting nuance on that will be to what extent you'll be able to argue that social distancing, that complying with these requirements, is the sole cause of failure to perform. And I think it's fair to say that that is likely to be pretty tricky. I flagged up before that, you know, the new guidance on contractual best practice, both from government and the Construction Leadership Council, is trying to encourage parties to embrace an early warning kind of relationship and trying to seek alternative solutions where the contract's not necessarily set up to deal with the circumstances we find ourselves in. So before I move on to look at the industry recovery plan, I always feel it's incumbent on me to give some tips. And so I've tried to put some tips together on this particular slide. And I think run in no particular order. One of those tips is, you know, I can't emphasize enough the importance of carrying out risk assessments on the works that you're doing, and obviously this is a subject for somebody that's technically experienced in those types of works. If you carry out those types of risk assessments, you can use that as evidence that you have complied, or that you're trying to comply, or you're unable to comply with the social distancing or with the measures and requirements in that guidance. I'm aware of further sector-specific guidance being prepared and at various stages of preparation by the various trade associations, for example, the Finishers and Interiors, Fit Out Sector Group, and also the Home Builders Federation. So for the particular works that you're carrying out, there may already be some guidance in place. And of course, that risk assessment is also also something that subcontractors may want to request from their contractors if they're anxious about going back to work, putting their employees back on a site. The next top tip is, early warning to try and encourage and facilitate dialogue between the contractual parties. Obviously, some of the standard form contracts already, like the NEC form of contract, already provide for an early warning mechanism. But then, of course, in the JCT contract, in terms of notifying delay and claims for loss and expense, they're encouraged to notify them as soon as it becomes reasonably apparent. And of course, the guidance that I've mentioned a few times, the best practice guidance, talks about giving the relevant contractual notices, but then also having this without prejudice discussions at the same time, in parallel to that, to try and kind of work a way through. That leads quite nicely on to collaboration, trying to collaborate to try and agree alternative ways of working. And of course, whether or not that is possible is completely dependent on the characters on site, on the people that you are dealing with, and their willingness to be able to engage with that. And finally, every top tip list has got to include record keeping. It's vital that you have the records to prove that site operations have changed to suit legislation, regulations and/or guidance. This will be critical evidence for any claim for delay and disruption, for additional cost. So can't emphasize enough how important that is. And if you need any particular guidance on what kind of records to keep or how to keep that, then we've got some more materials that we can cover. So, leaving the site operating procedures to one side, on the 1st of June, so a couple of days ago, the Construction Leadership Council published its industry recovery plan, its roadmap to recovery. You can download the many-paged PDF from the Construction Leadership Council website, or the article that I wrote recently. It's in the form of a PowerPoint presentation, but when you start to read it, it's kind of more apparent that it's actually more akin to a white paper. It sets out a series of proposals which are intended to help the construction and built environment sector recover from the effect of COVID-19. And also, and unsurprisingly, it's also directed at trying to deliver some long-held industry priorities, such as procuring for better value, a skill shortage, building safety, net zero carbon, innovation, and fairer contractual and payment practices. It's broken down into 3 phases over a 2-year period. We're starting from June. The first phase is restart, then reset, then reinvent, and built into those 3 phases are 4 sectoral recovery plans. So the intention is that there will be individual plans for the infrastructure, social infrastructure and construction, housing, and the repairs and maintenance sectors. The intention is that this plan will be reviewed on the 1st of September, ready for it to move into the next phase, into the reset phase. I've extracted on this particular slide a bit of a summary that I've prepared of the various stages and the periods that they cover. There's obviously significantly more detail in the document itself, in the PDF that's been prepared by the Construction Leadership Council. I think it's fair to say that many of the recommended actions in the report need the support of government, local authorities and construction clients, as well as the contractors and subcontractors. In terms of the first phase, the restart phase, some of the actions in relation to that phase include extended working hours on site, which has been pushed through by government, and also extended planning dates so as to not lose planning permissions for ongoing projects. In the reset phase, some of the actions include the delay of the VAT reverse charge. So that was pushed back already until, I think it was October 2020. They're requesting that that's pushed back further to October 2021. And they're also pushing for the acceleration of the ACM cladding remediation works. And then we move into the reinvent phase, bringing construction bigger and stronger. And that's all to do with the themes that the Construction Leadership Council have been pushing for several years, which are around fabrication and offsite manufacture, partnering, net zero, and digital technology. So you can kind of see the themes coming out of this. On this particular slide, I've just set out some of the key features of the plan. So it's pushing for more collaborative business models. I think it's fair to say there's more information that's required in relation to this, but alliancing and that type of partnering is certainly being mentioned. There's a push towards fairer payment and contract models. I've said about the contractual best practice guidance. and we'll see what kind of traction that gets over the coming weeks and months as the disputes start to appear and parties start to get out of this kind of immediate response phase. I think one of the things I would flag up is that there's issues such as retentions, for example, and the abolition of retentions been bouncing around the industry for several years, and the last government consultation that they did about retentions took over 2 years for us to get the results of that. So there is a bit of an issue with how quickly any of this can be achieved and whether or not it can be achieved without government intervention. Procuring for value is a key aspect, and this is all to do with focusing on the value and whole life cost and performance rather than the capital cost, and that builds on Anne Bentley's report from 2018. Another key point is that it's essential to minimise disputes in public and private sector. That's the key theme in this, and I think if the industry fails to do that, I think it's likely to unsettle the whole recovery plan. Stephen's going to cover the guidance in more detail and also the RICS conflict avoidance pledge, which a number of contractors have signed up to. So the last point on this slide is, is it make or break time for construction? It's not a question I'm proposing to answer. I just think it's something that we all maybe need to think about. Some of the issues that are covered in the recovery plan are things that have been booted around in the industry for years. Will this event be the impetus for change? Will government be forced to make legislation in order to push this through? And I think it's also important that the recovery plan itself recognises that it needs the collaboration and support and of all sides of the particular sector. The one last point before I hand over to Tom is that the Arcadis Global Construction Report was published today, and it made a point which I think is probably worth re-emphasising, that how the industry responds to this pandemic, so what it does now, will play a large role in the quality, duration and cost of construction disputes over the coming months and years. Thank you very much, and I'll hand over to Tom.
Thank you, Ruth. I'll just share my screen with yourself. You should be able to see that. Is that clear to you, Ruth? I think so. Good morning all to the attendees, and thank you to Clark's Legal for inviting me along today to give you some of my thoughts from a project planner's perspective of how COVID-19 may play out in relation to programmes and such like. I think to set the scene of the challenge that we're facing as planners is really to draw upon what Ruth mentioned in relation to the new site operating procedures and guidance that's out there. Clearly, we're now on version 4 of the Construction Leadership Council's SOP. A slight relaxation from the first edition as I see it, and we draw upon other documents such as the Department for Business, Energy and Industrial Strategies working safely during coronavirus construction and other outdoor works. And it's interesting to note that Ruth picked up on this term outdoor work because clearly construction is more than just outdoor works. And as I'll show in my slides, I think the internal trades will be the most suffer the most as a result of COVID-19. I think from a programme perspective, the key point really is that whilst these measures are clearly beneficial from a health and safety perspective, they will undoubtedly lead to further delay, disruption, which we mean by that is loss of productivity and increased costs. Contractors themselves are on low margins to start with. How this plays out in terms of profitability going forward is going to be key, for the maintenance of the industry as it is going forward. I think obviously this documentation are the constraints and parameters that we as planners now need to work to. From a programme perspective, during lockdown, if the site is shut down, then clearly from a programme perspective, it's quite a simple analysis of the works will simply push down to when they restart. However, the real issue going forward is this term, the new normal post-lockdown. How do we as project planners deal with the duration of activities and the like going forward, which will be, in my view, significantly different than they would have been pre-COVID-19. So putting that in mind then, and with this issue of delay and disruption, I guess the key takeaway from my perspective is the impact on sites is not going to be uniform. It's going to be non-uniform. It's going to be very difficult to predict the effect. It's going to be very unique to the site itself. Really dependent upon the trades and the proximity of those trades. Obviously, construction is typically gang related. How gangs can work together effectively going forward whilst maintaining social distancing measures is going to be very, very crucial. We've certainly seen decipher a difference between the nature of the project. So, for instance, we have seen certain highway projects continue throughout lockdown, where operators are working in their own individual plant, excavators and the like. They can continue pretty much as they were previous to COVID-19 without a major impact on their working. Conversely, though, we have seen some building contractors who've had to shut their sites entirely, have had to look at their risk assessment methods significantly to determine how, in particular, mechanical and electrical trades and finishing trades can work effectively in a close enclosed environment. Now, I've read some anecdotal evidence online of different disruption factors out there. For example, there was an article I read which stated that a gang of bricklayers it drew upon who said that they were working approximately 25% less efficient. And what they were saying, these bricklayers, was that the hod carrier who would previously have taken the bricks to where they're working at the workplace now has to leave them a distance away, circa 2 to 3 meters away. They, as the bricklayers, now have to go over and pick up those bricks. And even as a simple trade like bricklaying in an external environment has been affected by COVID-19. I've seen other suggestions of much higher disruption factors, as high as 75%. That was an article I read in relation to China reopening its sites in March. And the efficiency on site was significantly reduced in the order of 75%. So clearly quite a wide range here that we need to take into consideration in terms of how we plan the works going forward. But as I say, non-uniform is going to be very site specific, very much trade dependent. Just picking up on some of these factors then, what are the things that we as planners, I guess, need to be considering? Well, I think the key first point is the remobilisation. The duration of activities we had pre-COVID that would now restart clearly won't be able to restart to those durations that we had at the outset. We have to now factor in, obviously, ill health and workforce who may be unwilling to return. I've seen some evidence of that. Certain people don't want to go back to site yet until COVID-19 has dissipated in the UK. Obviously, there are companies on furlough. I've seen some subcontractors who furloughed all of their staff, and obviously public transport issues and the like. We need to also factor in, obviously, supplier subcontractor insolvency, which may arise. Unfortunately, this is continuing at some pace from what I read. It was a big issue late last year. Possibly COVID-19 will continue that trend, unfortunately. And social distancing in general needs to be a factor in how we plan the works going forward. I think as planners, we are used to working to what we call output rates, standard rates for how long it takes activities to be undertaken. So a metre square of brickwork has a set period of time and an average. A metre square of dry lining has an average period, and so forth. Clearly, there are no work studies around COVID-19 and around the real effect of what those factors now are of output going forward. So I'm interested to know how contractors deal with this issue of both planning their works and obviously tendering their works as well in that regard. A few other points that come to mind for myself are to factor in the following. Materials stuck in transit and ports abroad. We saw this. We had a Middle East contractor who was significantly delayed as a result of materials being stuck in China at the height of their pandemic in February and March. And those issues are now being resolved and worked through before any sort of formal dispute arises, hopefully, with our client. But serious issues arose as a result of differing impacts of COVID-19 abroad. Obviously, this may well lead to increased lead-in times and products potentially being unavailable. A key other factor in my mind is reduced logistics on site, in particular with regards to lifting goods and people up buildings. And I draw this in terms of high-rise construction. It's reliant upon the number of people that can be put in a hoist. If previously you had 10, you can only now do 2 people to maintain social distancing. This will clearly have an input and an effect on productivity going forward. So I can see a significant issue there that may arise. Other items to perhaps consider in our programming going forward are staggered breaks and shift working and potentially longer working hours. There's some evidence to see that certain councils are now considering reopening of maintaining, allowing sites to open later, up to circa 9 o'clock at night during the summer break. Obviously beneficial to the contractors to pull back lost time. Although I would say it potentially leads to further loss of productivity. There's studies that show that as you work longer, your output is reduced. So I raise a question whether contractors will perhaps be hit with a double hit of productivity, one through social distancing measures and then being required to work longer hours, causing additional disruption to their output as well. So perhaps an issue that may arise there from a cost perspective in particular. I think putting all of this into a whole, I think from my perspective, I think we're likely to see a significant change in critical path on projects going forward, and that projects will become much more sensitive to change going forward in terms of what is critical at any point in time. Now, perhaps pre-COVID-19, you had a nice flow of site activities. You could probably anticipate where the critical path may move to thereafter. Will that change going forward? Possibly. Will the design become critical because of furlough designers? Will the procurement fall on the critical path because materials are unavailable and such like? So certainly a lot more sensitivity in terms of what is critical at any point in time, in my view. Crucial therefore to record the status of the works on restarting if your sites are shut. And in my view, going forward, I would advocate a weekly update of the programme where you can. Keep it contemporaneous and issue, if it needs to be, to your contracting party that you're in contract with, to record really the status of what is critical at any point in time. An example of this is that we have a client who has maintained their site through the lockdown period with a reduced workforce. They've issued their notice of delay to their employer. There's been a little bit kickback in respect of the employer saying, well, the site is running still, what's your issue? Well, clearly the contractor has an issue in relation to not achieving the output and the rate of progress that they had pre-COVID-19. So I think recording that status of the programme on a regular basis is crucial in the coming months to hopefully avoid any disputes from arising. Briefly then, just touching on a subject that I think is obviously going to come to a head, which is loss of productivity claims as a result of COVID-19 measures. And obviously this is more of a cost claim than perhaps a programme claim, but it is closely related. And clearly loss of productivity claims are contract specific. Certain contracts will probably allow this type of claim more so than others. Obviously two lawyers on the call today, they've been able to advise better. In my view, perhaps more recoverable under NEC, which links time and money together, than perhaps a JCT, which splits the risk on time and money recovery separately. A key takeaway from my perspective, as a delay on this in having to deal with these sort of matters, is again records, daily allocation sheets and the like, setting out clearly what the workforce are doing on a daily basis, where they're working, what they can achieve, and crucially what they can't achieve and why. I think those type of records have over the past few years been poorly recorded by contractors. When I first started out in the industry 20 odd years ago. Why is it important, I guess, to keep site-specific records in that way? Well, I think if you're going to claim for loss of productivity, any contract allows it, then there is a sort of hierarchy of preferred approaches. In my view, you're much more likely to succeed where it's project-specific. You do some sort of measured mile or earned value analysis that looks at your loss of productivity specific to that site. And I think that is a preferred approach to the less preferred approaches, which are sort of industry comparisons, comparing your productivity against the industry at large, or even less preferred, simply saying it's cost us X and it would have we budgeted Y and the difference is what we claim. So I think lots of productivity claims will go hand in hand with the impacting of the programme from a delay perspective and any potential entitlement to an extension of time. But the key point, as Ruth picked up on, is record keeping. I think it's more crucial than ever going forward to do so. To conclude then, I guess on my slides, it's really just to pose the question then of how we go forward in this new normal. Ruth picked up on the Construction Leadership Council Roadmap to Recovery, the paper that came out 2 days ago. Quite an interesting paper from what I've seen of it. Sets out the 3 phases, as Ruth said: restart, reset, and reinvent. And they pick up on this lost productivity issue. And the quote there is the following: productivity, new approaches will be needed to compensate for the loss of productivity due to the requirement to implement government guidelines across construction and the built environment. What measures do they set out then for recovering productivity in the reset and the reinvent stage as well? The key things they say are digitalisation, continuing trend of that on site, and increased manufacturing technology. And the quote that they say is quite interesting: a presumption of off-site for works going forward, i.e. taking the works into the factory environment rather than to site to increase productivity. Be interesting to see whether contractors take this up further in the coming months and years, and whether that is a mechanism for recovering some of the lost margin that may well arise as a result of implementing these measures on sites. That's really my oversight of COVID-19 from a planner's perspective. Hopefully you found it of interest. I'm now going to pass you over to Stephen James, who's going to go through post-lockdown dispute avoidance and resolution. So thank you.
Thanks very much, Tom. Right, okay. Yeah, so there are two things I want to talk about. The first is dispute avoidance, what the sort of climate is for avoiding disputes right now, and secondly, if you can't do so, what's the state of play with dispute resolution in a COVID world? There are two documents that were published on the 7th of May, and they're complementary and they were developed in conjunction with each other. The first is the Cabinet Office note that Ruth's already mentioned. It's happily titled Guidance on Responsible Contractual Behaviour in the Performance of Contracts Impacted by the COVID-19 Emergency. Now, it's very important to appreciate with this note and any other notes of a similar ilk, they don't have strict legal force. They're non-statutory, expressly non-statutory. They expressly do not override contractual rights or other rights arising, however they do. It's really about creating a climate to avoid disputes before they become something more formal. It's a quite short note, it's only 4 pages, but it's worth a read, and it's really sort of form of strong encouragement from the government to do various things, to act reasonably and proportionately when responding to performance issues, to act in a spirit of cooperation and with the aim of achieving practical, just and equitable contractual outcomes. Paragraph 15 of the note gives some more specifics. I've slimmed it down a little bit on the slide, but again, there's strong encouragement on the parties to act reasonably and fairly in relation to certain common issues that come up in a construction contract, so relief for impaired performance, payments, extension of time, LADs, and everything else. As I say, it's not enforceable. If you want to sort of act under the scope of the note, but the other party doesn't, you don't have any relief or remedy that directly arises from that. Although it's sort of hinted in the note, if parties don't play nicely like this, there might be need for more statutory intervention down the line. The other document that's published on the same day, the 7th of May, was the Construction Leadership Council's COVID-19 contractual best practice guidance. I'd really sort of describe this as a toolkit for avoiding disputes. It gives some practical advice and the aim of promoting a dialogue between parties where there's potential for dispute that hasn't yet arisen. So it gives some guidance on the need for discussions to be on without prejudice basis and subject to contract. So that's of course so that you don't inadvertently give something away that can be used against you in formal court proceedings, and you don't enter into a deal until you're actually sure what that deal is. It sets out some discussion points that might form the agenda for a collaborative meeting, the same sort of things I put on the previous slide from the Cabinet Office note. It talks about the need to involve third parties. It's all well and good doing a deal with some direct line, but if there's someone else in the supply chain or an insurer or anyone else, funder, anyone else who'd be affected, they need to be taken into account in any deal that's or any accommodation that is reached. And also explaining the need to reserve rights. It's very important. Notices still need to be served, you need to have a fallback position in case you can't agree an amicable outcome. And the same goes with reaching a deal. Any sort of tacit understanding is not particularly helpful if down the line things fall apart. You say, well, I thought we had a deal, actually there was nothing legally binding. So if you reach some accommodation, and make sure that's properly documented, you know where you are. The other useful thing that's in the CLC guidance is in the appendices, precedent letters where a contractor might write to the employer to get the ball rolling for these discussions, and precedent where the employer responds. So it's really, it's not viewed as any sort of sign of weakness to have that discussion. It's open, sensible, and encouraged that parties have that discussion in an early stage to stop these disputes becoming something more serious. There are also precedent notices as required for the signing forms in the NEC and the JCT. Now, the third document is the RICS Conflict Avoidance Pledge. This is something that's been around for quite a while, but has achieved some more traction recently. It wasn't written specifically for the COVID world, but it's highly pertinent. And in the last month or so, some larger entities have signed up to it, signed up to the pledge, and it's also been formally endorsed by construction bodies such as the CLC and ECA. I won't read the pledge in full, but it's relatively short. It's half a page or so. But the 5 key themes are a commitment to collaborative working and early intervention techniques, to embed in contracts conflict management mechanisms. So again, this is to avoid disputes before they become something more formal, and working proactively to avoid those disputes, to identify them early on, and commit to work with industry partners to avoid those disputes. And I say 123 businesses have signed up when I checked yesterday evening. So all well and good if you can avoid disputes becoming something more formal. But what if you can't? What's the landscape now like as far as dispute resolution goes in the construction world? Well, the right under the Construction Act to refer a dispute to adjudication at any time is unaffected by COVID. There's one example right at the start of lockdown where a responding party to an adjudication tried to get the adjudication put on hold until the end of lockdown. This is the case in Millcrest Development. The court said no, although there's some practical difficulty. For example, the responding party solicitor was self-isolating. The judge said these could be accommodated and the adjudication must go ahead. I'm not aware of any other attempts, but I suspect they get a similar response from the court if those attempts were made. To my mind, adjudication ought not to be drastically affected. It's in general a remote process. There might be meetings between the parties and the adjudicator. There might be site meetings, but they are the exceptions to the rule, and an adjudication can pretty much carry on as normal. I've done adjudications during lockdown, making as I would have expected otherwise. I think adjudicators will be alive to the possibility of a short extension of time, because an argument for a breach of natural justice is something that would potentially render the adjudication decision unenforceable. So a short extension of time might be forthcoming. For any party to adjudication, before they kick it off, just consider the practical issues that may arise. Documents on site that's currently inaccessible, witnesses on furlough, just so you've got your case ready. There are 2 adjudication schemes that have been developed specifically to address COVID and to give a more cost-effective solution for smaller disputes where adjudication costs would otherwise be disproportionate. The first is the low-value dispute model adjudication procedure. This is for claims up to £50,000, although it can be extended by agreement. The procedure is streamlined and the adjudicator's fee is capped at particular levels. The maximum fee is £6,000 for a £50,000 claim. The RICS has recognised that even the low value dispute scheme may be too expensive for very low value claims. So it's developed a summary adjudication scheme where the whole timescale is just 2 weeks from start to finish. It's for claims up to £20,000, and the adjudicator's fee is capped at £1,000. And the adjudicator just gives a one-page decision. So court proceedings, well, to a degree, it's business as usual. High value claims that are dealt with in the technology and construction court. Court users are fortunate in that electronic filing was adopted a few years ago. So practitioners and parties are used to dealing with cases electronically anyway. The CPR has quickly been updated. I think we've got Practice Direction 51ZA. There's some tweaks that just help facilitate remote working, making it easier to extend time for various things. Hearings are now almost exclusively remote. They take place via Skype or Zoom or whatever technology can be agreed between the parties. And the presumption is that hearings are expected to go ahead. There have been some attempts to postpone hearings, particularly trials, because of COVID. The court's presumption is that they should go ahead and the parties should work together to make sure they can go ahead. It's certainly true that parties can expect some delay and cases won't come to a final hearing as quickly as they might have done otherwise, notwithstanding there's apparently been quite a large drop in the number of claims issued recently. My experience is the position's not quite so rosy in the county court, where lower value claims are dealt with. The infrastructure for electronic filing is not yet in place, and any sort of remote or electronic working on an ad hoc basis. Mediation is something on its face would be dramatically affected by lockdown and social distancing. Other than very low value disputes that can be dealt with by telephone mediation, which in my experience is a bit rubbish, but any other mediation would invariably be face to face. The parties, the mediator, the legal representatives, the expert, all together in the same building and frequently the same room, which clearly isn't an option right now. The mediation industry has quickly pivoted to mediating remotely. There are lots of technical tools that help, and we've all become very familiar with Zoom and the like. You can have separate breakout rooms, so you can recreate the mediation environment remotely. And it's been suggested that actually there are advantages to mediating remotely. I'm clear there are practical savings in travel time and everything like that. Anyone who's participated in a mediation will know there's an enormous amount of downtime during the day, and if you're in your home office, you might spend some of that time more productively than otherwise. It's also been suggested that the sort of ubiquity of video conferences that we've been experiencing over the last couple of months means there might be a greater involvement between the mediator and the party actually in dispute, as opposed to their representatives at an early stage, and that help cut to the chase and see whether real issues are in dispute. Just by finish off my slot, mention a word about winding up petitions. The Corporate Insolvency and Governance Bill was published a couple of weeks ago. It's earmarked as fast-track legislation. It's not yet on the statute book. The latest intelligence I have is that it's likely to become law by the end of June. Effectively, it prevents winding up petitions completely. It was sold when the press release a couple of months ago as being protection for corporate tenants. It's actually much wider than that. It prevents all winding up petitions for between the 27th of April and a month after the bill becomes law, so probably to the end of July. In theory, there is a mechanism to show the inability to pay debts is unrelated to COVID. but in practical terms, it's going to be very difficult to establish that. So essentially, the message is that winding up petitions are off the menu for the immediate future. I don't see this as having an enormous impact on the construction sector. Petitions are only available for truly undisputed debts and where there's no counterclaim or cross-claim, and in a construction context is often relatively straightforward to at least advance some sort of counterclaim that would make a one-year petition a risky path to adopt. And finally, I've mentioned that the bill applies only to companies. There is no equivalent restriction on statutory norms served on individuals or for the service of bank petitions. So if you're dealing with a sole trader individual, there is still the insolvency option to go ahead. Right, so that's the end of my slot. We have a couple of minutes for questions. I'll just check my notes to see if we have any. So I've got one here, and Tom and Ruth, are you back with us?
Yeah, we're here.
Okay, so I've got, perhaps I can give this one to Tom first of all. It says, what do you mean by record keeping? How detailed do we need to be? What would you expect to see, Tom?
Yeah, so obviously there's various records that constitute good record keeping on the site, and they differ from in a few ways. So firstly, there's program records. You then have cost records, and then other records, contemporaneous records. From a program perspective, clearly it's to update the program progress on a regular basis. So you have your baseline program to start with. On a monthly basis, as a minimum, you keep record of the progress, percentages of trades of activities that have happened. You also record the actual start and actual finish date of activities that have actually started or actually finished. That's from a program perspective. Clearly, there's other supporting contemporaneous records. So I would include things like daily allocation sheets. I mentioned those to me are really key in the sense of recording what the workforce are doing on the site on a daily basis, where they're working, why they can't do certain things, and particularly where, as mentioned, disruption claims and the like arise. I would also add to that list photographic evidence. As a delay analyst, I think it's very convincing photographic evidence when we produce reports to say, you know, to show to an adjudicator or such like in the tribunal, this is what's actually the status of the works on that date. Very hard to argue with. I'd also add perhaps daily site diaries is often another record that's quite useful when they're done correctly. That seems to be phasing itself out over the years. When I started out as a graduate, it was something I did on a daily basis. That was my task. We don't see it as often these days, but that type of record. And then you have the cost records themselves, which are really what the QSs and such like would record. So it's a mixture of different types of record, all just giving a contemporaneous view of what's happened. So they have the records at the time. Ideally, they're issued to the contracting party that you're in contract with on a regular basis. So there's no debate over the factual status of those at any point in time. So quite a broad mixture, really. So it's the remit of the project planner, the site project manager, and perhaps the QS as well, to keep their own individual records for their individual.
Just a clarification. Thanks very much for the comments here about the contract avoidance pledge.
So, I mean, I think, have you got anything else to add in relation to that? In relation to record keeps, wanted to add that we can't, from my perspective, I don't really dictate what kind of records that are kept on site, and obviously records that Tom said are very, very useful, and all of those types of records offer really good evidence and print on site. A perspective is that firstly, of the time there's telephone conversations, they're not followed up by any kind of record like an email or a attendance note, a kind of a note in somebody's diary. And I think I'd quite encourage people to keep notes sometimes of their telephone calls, because quite often they'll say, well, I spoke to so-and-so, but then they can't remember the particulars of what was said. And then the other thing to consider is trying to keep those records in some kind of order so that they can be searchable, because of course disputes may arise several months or years after you've actually completed the works and created those records.
Just to thank Ruth and Tom for joining us today. Quickly, that we will be sending out the slides to everyone after the presentation. And just a very quick clarification about the contract avoidance pledge. It's not just from the RICS. There are various other bodies that have been involved in putting it together, and TfL and the Network Rail on the steering group, and there's actually 152 signatories right now. So again, thank you all for joining us. Hope we didn't lose you at the end, and have a very good day. Thanks, bye.
Thank you.